Rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Scott Maycar, Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, this honorable court. Please be seated.
Well, good morning, everyone, and welcome to the 5th District Court of Appeal. Today is the Complex Commercial Case Day. We've got two cases on our docket, and we will start with case 24-1156, Deltona Transformer Corporation. With me today are Judge Soud and Judge Boatwright. Let's pronounce those names correctly, right, Judge Soud? Had some very interesting mispronunciations the last couple of years. So we have, I believe, 20 minutes per side, and the appellant, of course. I guess we have a, let's see, is there a cross appeal on this one? No, that's the second case, okay. So if the appellant would just let me know what time you want to reserve, we will do so. Counsel, you're prepared to proceed? All right, please do so.
Good morning, and may it please the court. My name is Tara Price of Schutz & Bowen on behalf of Appellant Deltona Transfer Corporation, or DTC. I'd like to reserve 5 minutes for rebuttal, please. This is an appeal where the trial court failed to follow Florida law in the face of contentious litigation among family members. In this case, a father who ran a successful corporation subsequently gave shares to his daughter, sons, and 2 nephews. Only a few years after that, this suit and many others followed, alleging that the son and nephews wrongfully ousted the father and daughter so that the son and nephews could take total control. Today, I would like to discuss 3 of the trial court's 5 errors that we've provided in our briefs. First, the trial court erred when it ruled it lacked the authority under Section 607.1436, subsection 1, Florida statutes, to set aside or modify Deltran's notice of election based on the equities. Second, the trial court erroneously ruled that it was forced to choose between 2 expert witnesses' opinions that it concluded were wrong. And third, the trial court entered the valuation judgment and ordered payment without complying with Section 607.1436, subsections 5 and 8. Because the trial court failed to follow Florida law and entered a valuation for the Class B share based on the wrong legal standard, this court should reverse the valuation judgment and remand for additional proceedings in compliance with Florida law. With regard to the first issue, the trial court erred when it ruled that it lacked the legal authority to even consider whether it could set aside Deltran's notice of election based on the equities.
So I agree. I tend to agree with you that the irrevocable language is followed by unless. So I tend to agree with you that that seems to at least provide a limitation that this could be set aside. But how do you answer the appellees, at least their response to part of this, when you read subsection 2, which seems to be, to me, to be the procedure and how this would follow? And in the last part of subsection 2, it seems to exclude, it says other than the petitioner, seems to exclude the petitioner from being able to, at least the appellee argues, from setting aside the election. The setting aside would only be for the corporation or the shareholders, it appears, that are making the election.
Yes, Judge Boatwright, I'd be happy to explain. The appellee's argument is based upon subsection 1 being nested within subsection 2. But in fact, these are different subsections. Subsection 2 applies that particular sentence when the petitioning shareholder wants to either dismiss the underlying dissolution proceedings or wants to somehow settle the action or wants to subsequently sell their shares to some other entity besides the corporation. And so when that happens, the statute directs that the trial court is supposed to consider the equities with regard to the electing corporation and shareholders. We don't see that language in subsection 1. And as the New Hampshire Supreme Court ruled in the Bendenson case, the word in section 1, irrevocable, displays an intent to bind both parties. Both the electing corporation or electing shareholders and the petitioning shareholders are bound. And so it also looked at the Model Business Corporation Act, section 14.34, comments.
Was this statute based off of the Model Business Act?
It is my understanding, Your Honor, that Florida is a Model Business Corporation Act state, yes. And that comment, too, talks about how the purpose of this statute is so that there isn't any type of gamesmanship or there isn't any type of strategic advantage that's being used, both when the petitioning shareholder tries to dissolve a corporation and when the electing corporation or the shareholders file a notice of election. And if we only had it working in one way, you wouldn't have that protection for the petitioning shareholders. I'd like to note that the Florida legislature has been, in recent years, very concerned with the equities with regard to petitioning shareholders. In 2019, we saw an amendment to this statute in subsection 7, which previously used to allow a corporation that elected or that filed a notice of election to wait until after the valuation proceedings were finished, decide whether it liked the value that was given to the shares, and then it could unilaterally decide.
What's the effect on your client if Deltran is dissolved versus the shares being purchased? What's the difference there?
Your Honor, the difference would be that DTC would. There are certain rights that Deltran is exercising that belong to DTC, for example, like a worldwide license agreement. That's part of a separate suit. But certainly if Deltran no longer exists, then DTC would have those rights back.
I believe the daughter, she had her shares purchased and she decided not to appeal the issue, correct?
Yes, Your Honor. I do not represent Ms. Dion. I'm here on behalf of DTC.
So there is a difference between, in your mind, dissolving this versus the shares just being purchased.
Absolutely.
There would be a difference to your client.
Oh, absolutely, Your Honor, absolutely. And, this Class B share that DTC owns, it's significant. I mean, if you look at the Articles of Incorporation, it's not like your typical share. It exists. It doesn't have a vote on every single issue, but
it has veto prerogatives in some instances.
Yes, Judge Stout, absolutely. And over very important issues, there are 5 of them, including the disbursement of dividends, including equity acquisition of another corporation, including debts over a certain size. And if you were to look at, I believe it's appendix page 74, you'll see Deltran's answer and counterclaims where it admits that the Class B share was created to protect DTC's to make sure it could continue to get payments under the various notes that it had with Deltran. And so this is a very important share that, as it existed, had an incredible value to DTC beyond just some market value.
If we agree with you on the first issue, about the statutory interpretation issue, and we remand it, what happens? And also, secondarily, what about the other issues, or how are they affected? In other words, if we agree with you on the statutory interpretation, the trial judge misunderstood the statute, said, I can't go there, I can't do equity, and we send it back, what is that going to look like, and how does that affect the rest of your case on appeal?
Yes, Judge Makar. Although we would agree that there are numerous reasons to reverse and numerous instructions that should be given to the trial court. If the trial court were to reverse on this particular issue, if this court were to reverse on this particular issue, the trial court would need to hold a hearing where it actually allowed DTC to even make a case to present the equities. That would be with regard to the Class B share, because as Your Honor recognized, Ms. Dion has not appealed. And so if the trial court were to examine the evidence and then determine that the equities required that to be set aside with regard to the Class B share, then we would have, if that was appealed, something before this court as far as whether
Well, to follow up on Judge Makar's question, wouldn't that reset everything? Because if you set aside the election, then now you'd be pursuing dissolving, not dealing with purchasing shares at this point. Is that, I mean?
I see. I understand. My apologies. Yes, I think that's right, but this is what should have happened in the
So that
first-
would, following up on Judge Makar's, I think what he's, I don't want to put words on what he's asking, but it would reset, I mean, you'd be dealing with whether this, at that point, looking at whether this should be dissolved, not dealing with these other issues. Is that correct?
We would be looking at to whether it's equitable for the trial court to set aside or modify the notice of election.
And if they did that, then it would be
We would be back to
proceeding on a
dissolution.
dissolution proceeding, not dealing with purchasing the shares or in that instance, correct?
That's correct, Your Honor, but it's not just because this court reverses, there's going to be a dissolution of the corporation. There's still many, many steps before we get to that point, if the trial court were to get us to that point.
Is there any argument, I don't recall whether I believe made, that it's harmless?
I didn't.
The equity was done in the judge's mind, and that sending it back to have this hearing to say, well, is it equitable or not? Well, hey, I've already kind of done what I thought was the right thing to do.
Your Honor, I don't believe that issue is raised on appeal. However, even if this court were to consider it, I think the legislature, I think the error has to be harmful because the legislature has directed the trial court that it can consider whether to set aside or modify based on the equities. And so prohibiting DTC from even being able to make a case, not even getting a ruling as to whether
Well, that'd be like a due process argument. You've been denied your due process right to make your case.
it would be harmful.
But what would you present in this hearing on remand that you haven't already presented in the main case?
Your Honor, there in our appendix, there was a motion to set aside, and I believe that raised a number of issues beyond just what was in the complaint, and so certainly those issues would be argued. And then, of course, the parties went back and forth on the supplemental memos with regard to the legal issues. But the trial court never actually made that determination, never actually made that consideration. So this is a denial of an opportunity that the legislature has determined rightfully belongs to the trial court to ensure that these types of proceedings are fair. These are all equitably based. Corporate dissolution is based in equity. Valuation of shares is based in equity. Whether to set aside a notice of election is based in equity. And to agree with Appley's argument is to kind of rob the trial court from having the ability to look at the equity, even if there were a situation where an electing shareholder were going to have an unfair advantage.
In regard to the value of the Class B stock, I mean, there's the stock, there's quite a big difference between the two experts, correct?
Yes, Your Honor.
Okay, so what other evidence was available to choose a different value? I mean, it's kind of left the trial court in a position to choose one or the other. Was there other evidence available where the trial court could have come to a position? It seemed like the trial court wanted to come to a position more in the middle and did not.
Yes, Your Honor. The trial court certainly made a number of statements during the valuation hearing, and the valuation and judgment itself evinces that.
But isn't that on the parties to provide, I mean, different alternatives? I mean, you kind of provided one, they provided one, the judge chose one of the two. Why is that not within the trial court's discretion to do that at that point?
Your Honor, I believe it is within the trial court's discretion, if I'm understanding your question, to be able to look at the evidence in its entirety and to be able to take, I think what happened is the trial court was focused on, I have an opinion that it's this 567,000 number, and I have an opinion that it's this 3,380 number. And I've got to pick one or the other, and I don't like what underlies either of them. And so, I mean, the trial court even asked in the underlying proceedings, if I reject one, don't I have to accept the other? But what this court has previously ruled in the Ramphel case and the Lally
But she
case,
was, the trial court judge was informed that it did not need to do that, correct?
yes, Your Honor,
Okay.
DTC trial counsel did inform the trial court that did not need to be done, that she could have looked at the different methodologies, she could have fashioned her own number, she could have looked at evidence such as Judge Stroud's comment about having a veto vote, how many different votes are there. There are a number of things. But at the end of the day, if there wasn't enough evidence, The Ramphel case also shows that the trial court could have asked the parties to go back and submit more evidence. Simply because there isn't enough evidence in the proceedings doesn't mean that it's okay to enter in a wrong valuation.
Was that asked?
I don't know whether that was asked, Your Honor.
Okay.
Are there still other pending lawsuits dealing with this issue?
Yes, Your Honor.
As I read in the briefs, are there five, or in the record, are there 5 pending lawsuits?
There are, I'm not trial counsel, so I don't want to misspeak. I understand that one may have been settled. I understand that another was ruled recently in DTC's favor on summary judgment, and there are other suits that are heading for trial. It was supposed to happen this past fall and has been continued.
Any of those suits would affect any of the issues here in this appeal?
Only to the extent if the trial court is looking at, well, I guess, I'm sorry, can you rephrase so I make sure I understand your question, Judge Becker?
Yeah, I saw where there were 5 pending lawsuits dealing with all these issues. I wondered if that would have any bearing on this appeal. That was the only
I don't know that the issues in those lawsuits necessarily would decide issues in this lawsuit or vice versa, but there may be decisions made in other lawsuits that show either mismanagement or bad judgment or you know what I mean, decisions like that. That certainly could be evidence that could be used in this case, certainly. I see that I'm getting close on my rebuttal time. I do want to briefly just state that the trial court's valuation judgment was not made in compliance with subsection 5 or subsection 8. Appellees have no argument with regard to subsection 8 other than its harmless error. And I believe the court should disregard that because it's not based on any evidence that the trial court had in front of it and is insufficient in its own right. And I believe that subsection 5 speaks for itself when it requires the trial court to enter an order that includes decisions as to whether there's an entitlement to awards and fees or as to whether the petitioning shareholder had a right to bring the petition for dissolution in the first place. These are significant errors that have a real impact. And we're talking about statutory procedures where a corporation comes to a court to ask for assistance to take a shareholder's property that they're unwilling to sell. And so we have to be able to allow the trial courts to evaluate the equities in these types of situations. The legislature would certainly want the trial court to follow the Florida statutes as they're written. And because that was not done, DTC requests that you reverse the valuation judgment and the erroneous rulings with instructions on remand for further proceedings.
Thank you, counsel.
Thank you, Your Honors.
If it may please the court, my name is Halla Sandridge, and I represent the appellees who I will refer to collectively as Deltran. I would like to start first with a response to the issues related to the construction of subsection 1 in 607-1436. The only way that DTC gets to where it is by ignoring the words of the statute itself. We filed supplemental authority, the Lumpus case out of the Florida Supreme Court, and it would require this court to use and apply the common understanding of the word election and irrevocable and give them their plain meaning.
Well, the statute does say irrevocable, but then it says unless. It places a limit on the irrevocable nature of that, doesn't it?
Yes, and let me go through exactly what you just said, Your Honor, and explain to you why the exact language of the statute supports our argument that the only party that can seek to revoke the election is the party making the election. So let's take a look at subsection 1, and it says, an election pursuant to this section shall be irrevocable. It doesn't stop there. It says, unless the court determines that it is equitable to set aside or modify the election. So an election pursuant to this section shall be irrevocable. We know who makes the election. Only the shareholder or the corporation make the election. Then it says it shall be irrevocable. Under any common understanding of that phrase.
What would be the rationale? Why the rationale for not allowing the petitioner petitioning for dissolution and just the party moving for the election to be able to have it set aside for equities? What would be the rationale in that?
The rationale is that the Florida legislator, and we'll get to the commentary in a moment, wanted to end the litigation, wanted to be able to allow corporations to proceed if minority shareholders were unhappy and could be bought out. Imagine, Your Honor, a 1% minority shareholder. They would have the right to file to dissolve. And if the majority shareholders running the corporation successfully could not buy out that minority shareholder, Florida corporate law would come to a screeching halt. And so our legislator wanted the the electing shareholders to be able to come in, make the election, and go forward with it.
But that could be considered as part of the equities broadly, could it not?
I don't believe we get to that issue because of the way this sentence is structured. And just so you know, and this is very interesting to me, the Bendenson case on which they rely, which was rejected by the Utah case, the Hills versus Nelson case from the Utah Supreme Court. Here's what it does, and I think this violates Florida Supreme Court principles. In Bendenson, the court admits, we agree with the respondents to the extent that the term irrevocable commonly describes the relationship between an actor and an action initiated by that actor. Thus, generally speaking, if an action is irrevocable, the actor who initiated the action may not withdraw it, alter it, or otherwise call it back. You would think with that determination that would end the story because of how irrevocable is commonly understood, and that's what our Florida Supreme Court asks us to do. But then the New Hampshire court goes on to look at commentaries to find that it will not use what it has described as the commonly accepted meaning. So we believe, and even the New Hampshire Supreme Court agreed with this, that when you are looking at this language, it is referring just to the party who is making the election. And then the language, unless, is the limiting language on the party making the election. And it makes sense that there might be a scenario where the party making the election would need to have the court adjust it, modify it, or set it aside. There could be a death. There could be something that happened in the corporation to value the shares so high that they could no longer afford to purchase them. So there could be equitable reasons in which the election should be set aside.
Does the language in subsection 2 or section 2 support the reading of section 1?
It does. We are not saying it is subsumed within section 1. We are saying that they are separate sections, and they each define a separate scenario. The first scenario in subsection 1 is all about our election and whether we can revoke it. Subsection 2 deals with scenarios where the petitioner may come in and ask for different relief. And it gives very specific situations in which they can do that. So
you agree with the appellant on that they are two different provisions?
They are two different provisions dealing with two different situations. The first one, again, is the ability of the electing petitioners whose election is otherwise irrevocable unless the court determines that it is equitable to set it aside. So what would happen is that if we made the election, we would have to go to the court in order to revoke it. And the legislator set a standard. The standard is it has to be equitable. And it's interesting to me that... How do you read subsection 2? What do you say subsection, what do you read subsection 2 as? So subsection...
You said you see a differentiation between the two.
So what subsection 2 does is it talks about after an election is filed, it talks about very specific scenarios in which there can be a scenario of settlement, of discontinuation by the petitioner, of its action, all things that might affect the election. It's a completely different scenario. And what it does is it sets forth the rights of the parties under those specific scenarios: discontinuation, settlement, and sale. In those situations, the court says it also can be set aside, but what we're going to look at is whether or not it is fair and equitable to the electing parties. And here's why that language does not need to be in subsection 1. Because of what I've just said. Because subsection 1 already has it built in. Obviously, we are the electing shareholder or corporation coming to the court and asking for it to be set aside. The court doesn't have to determine whether it's equitable for us because we're the ones asking. So the fact that that language is not in there is totally consistent with the way we have construed it to the court. So let me go back to one of the cases that I think is important here, and that is the Hill versus Nelson case, 2022, out of the Utah Supreme Court, and it addressed Bendenson, and it rejected Bendenson, and it looked at its own commentaries, and it said exactly what I'm saying to you, Your Honor, that it should be construed in the manner that allows only the electing shareholder or corporation to revoke its election. And if we don't believe that this court needs to go any further than the plain language of subsection 1 and subsection 2, but if the court needs to, the commentary to the Model Business Act in Florida says that the right of the electing shareholder or corporation is absolute, and that the reason for that is so that they can control ending the litigation. Judge Boatwright, you asked why. What would be the policy reason? Again, it goes to ensuring that if a motion or a petition to dissolve a corporation is filed and causes havoc in the operation of this corporation, Florida has an interest, the legislator has an interest in its commercial companies proceeding and having a healthy commercial environment. And what it has done is it has allowed the majority shareholders to not be held hostage by let's again say a 1%, and that's what we have here. DTC has 1 share, and it is now holding us hostage. And allow...
It's a different class.
It is
It has a Class B share.
He has
It doesn't have 1 share of 100 other shares. It has 1 of 1.
It has one
That
of
would certainly be relevant to the analysis, would it not?
I wouldn't disagree with you that if we ever got to that point, it might be relevant to the analysis. But again, we don't get to that point because the statute doesn't give DTC the opportunity to come in and revoke the election. And that is what the appellants do in this case. They ignore the language election and section, and the way they say it reads in their reply brief, they say the answer brief dances around the plain language of subsection 1, which authorizes the trial court to set aside or modify the election if the court determines that it is equitable to do so. That is not what the statute says. The statute is very clear on its face that it says unless the court determines that it is equitable. If, for instance, it said an election pursuant to this section shall be irrevocable, period, and it didn't have the limiting language following unless, then maybe their argument could carry some muster. But it doesn't here when it has this limiting language. And so we believe that their statutory construction argument is flawed under Florida law. It should be given its plain meaning. And if we have to look at the commentaries, the only Florida commentary supports our reading of this specific statute. Judge Makar, I wanted to address a question that you had asked about whether the court had already found equities in favor of my client Deltran. And if you go to footnote 5 on page 10 of our brief, we do say, in a later hearing, the trial court again agreed with Deltran that plaintiffs created this situation when they filed this lawsuit, and that Deltran was doing nothing wrong, but rather exercising a right the Florida legislator gave it. So that finding has already been made. I'd like to turn to the two other arguments that the appellant has raised today. The first goes to the issue of the expert testimony. So Judge Boatwright, you asked, I think, some very pertinent questions on this, and I'd like to address some of them. Number one, they never asked the court to continue the hearing or to set a new hearing as to the valuation. That seemed to happen a lot in this case, where there were problems that they now raise on appeal that they could have fixed in the trial court, and they did not. I think that is a preservation issue. Number two, both parties agreed that the trial court did not have to accept the expert testimony. And what happened during those arguments is that counsel for DTC said, we want to be able to explain to you what that other evidence is that you could accept. Can we submit proposed orders? And my brief lays all of this out, Your Honor. And they did. The judge said, absolutely, I want to hear what other evidence there is. And so what does DTC do? They submit a proposed order, and the only evidence they cite is their expert's testimony that the share is worth $560,000.
Did the trial court make any factual findings as to how they arrived at this?
Yes, and I think this is a really important point, Your Honor. No judge has to use the magic words, I find competent substantial evidence. All that they have to do is cite to that competent substantial evidence. And our trial court judge did. On page 10 and 11 of the trial court's order, she outlines in an entire page what that testimony is. And I would agree it was a little glib of her to maybe say that our expert's testimony was not clearly wrong, but then she goes on to say that the court finds that Ms. Womack, that was Deltron's expert, that her opinion is consistent with applicable legal authorities. So right there, she has found that we have satisfied our burden. And then she goes through on page 10 and lists all that evidence. What Ms. Womack said about the voting rights, about her study of public companies, comparing voting and non-voting stock, and how she valued it at 1% and then took 5% of that share for the voting rights and came up with the number she came up with. So to say that because she said, well, Ms. Womack is not clearly wrong, that there wasn't competent substantial evidence, simply because she didn't use that phrase, that is wrong. I'd like to also touch on the issue of the argument that the judge did not follow the statute related to the solvency finding. So here is what happened, and again, I think this is a preservation issue and also one of harmless error. So during the course of the proceedings, Deltron asked the trial court judge to sever the solvency finding, and it makes sense. Look, judge, go ahead first and determine value, and then we'll determine solvency, and then we can have an order that orders the payment once you find solvency. I'm not sure why, but it took the trial court judge a number of months to decide this case. And in it, what she did is she determined valuation, and then she ordered payment. At that point in time, and I don't know why, DTC should have said, filed a motion for a hearing, and asked the court to first determine solvency. Say, Judge, you forgot to do something. We severed the issue of solvency. You haven't done it yet, and we need to decide that first. They didn't. They just sat back. You see that happening a lot in this case. And so instead of that, they waited to get paid. And remember, Ms. Dion received a $2.3 million payment, so she wanted her payment. So we filed an affidavit of solvency, which satisfies the statute, which shows solvency, and they never contested it. It just sat there. We then submitted payment, and Dion accepted it. And the only thing that we have is DTC, who didn't accept it, despite the finding of solvency. There is no evidence that any of these payments render them insolvent. The only testimony shows that the company is solvent even after the payments. And the only remaining payment is in a trust account and available to be paid. So on the three issues that they have raised today, the issue of statutory construction, the issue of solvency, the issue of whether or not the judge has followed the statute, and the expert testimony, all of them are arguments that fail, and really this court should PCA this case. It does not deserve to have a written opinion. I believe that the language of the statute is clear and that the court can simply affirm this, and we would ask that the court do so.
Well, you'd take any affirmance, I'm sure. So, well, a question on the Class B share. I mean, it kind of raises the judicial eyebrow a bit that it's valued so low. I mean, if I have one share of stock and I can veto anything, not anything, but a list of things the corporation can do, that's power. That's a tremendous power and I think value. So walk through again in the little limited time you have. What evidence is there to support that value is?
Sure. So I think the evidence, again, which is on page 10 and 11 of the final judgment. Judge, the value of a share typically in a corporation is the monetary benefit you get from the share. And all of these experts admitted they'd never seen a share like this before. It was very unusual. And these were experts with decades of experience trying to figure out how to value the valuation of a share that holds no monetary benefit and a limited control right, this limited right of veto. It was troublesome. It was troublesome for everybody. And so what this expert did, and she says, is that she went to studies of public companies comparing voting and non-voting stock, and she came up with an analysis which is 1% of the total company. That 1% represents the one share, which is a $6,700,000 company value, and took the 1% of that, which is $67,000, and then took 5% of that to represent the value of the share. Your Honor, it could have been 10%. It could have been 20%. She came up with 5%. Nobody is here saying that's right or it should have been higher. And so I believe that the evidence is competent, substantial evidence, and the fact that it could have been a little higher does not make it not competent, substantial evidence.
I'll give you 45 seconds to conclude, if you'd like it.
Thank you. I have concluded. Unless there are any other questions?
We're good.
Thank you.
Thank you, Your Honors. First, I'd like to talk about the setting aside the election argument under 1436 subsection 1. Appellees discussed the supplemental authority they filed, which I think is interesting because what we see from the Florida Supreme Court is that trial courts are not allowed to ignore words to narrow statutes, and that proper statutory interpretation requires reviewing statutory provisions in the full textual context of which they are a part. And you'll notice in that case the Supreme Court considered multiple subsections when it made its decision. And it ultimately ruled that you can't add words in order to narrow a statute. And in that particular case, it was a situation about whether a creditor could come after a bank account that was owned by a husband and wife, and whether the account was made in their name or whether the account was originally made in the name. In order to get to the ruling that the trial court had, you had to add the word originally to get there.
Could I quickly ask a quick question? Could you have multiple petitioning shareholders in a case? In other words, could more than one shareholder be a petitioning shareholder?
I don't know of any reason why you couldn't, Your Honor.
Okay, so you could have multiple petitioners, correct?
I would believe that you could,
Okay.
yes.
In
Your
this
Honor.
case, we have just
I
one.
mean, in this case, we had multiple petitioners. We had DTC and we had Ms. Dion.
Okay, so, but were they petitioning together or they petitioning separately?
I mean, it's in the same complaint.
Okay,
So
so
it's
I mean,
the same count. Mhm.
Okay.
Yeah.
Okay, 'cause I'm just, the subsection 2, where it says "other than petitioner," seems to me it has to have some kind of meaning. And that, to me at least, and maybe I'm wrong, it sounds like no one's on the same wavelength as me, but it seems to suggest that when the petitioner seeks this election, or when the petitioner proceeds, that this "other than petitioner" language must have some effect on subsection 1, excluding the petitioner from.
I don't think so, Your Honor, because the actions that we're talking about for subsection 2 refer to dismissing the dissolution count, refer to selling the shares to an entity other than the corporation, refer to settling or removing the court's power from the action. What we're talking about in section 1 is setting aside the election and reverting back to the dissolution proceedings. And I think we saw the trial court was confused by that on page 280.
So subsection 2 in your mind doesn't discuss the procedure of the election process and then potentially setting it aside?
Your Honor, I believe section 2 discusses the procedure if a petitioning shareholder, or I'm sorry, excuse me, if a shareholder were to elect and then the corporation has notice requirements and then other shareholders can elect and then they become parties. And then it talks about, well, if the petitioning shareholder wants out, right, wants to say, oh, never mind, which is what the trial court said, then they have to follow this process and the trial court can look at the equities. But the trial court thought it couldn't even get to that point. The trial court thought, oh, well, I can't.
Here's what's in my mind. The petitioning shareholder says, I want to elect here too. And you've made your election. That means you don't have to worry about the equities any longer, right? If you elect a.
I don't think the petitioning shareholder can also be an electing
Okay, well, I guess I'm confused. Then what I'm saying is the election, you've elected the path you want to go on. Whether it's equitable or not, you've elected it. I think that's what I heard Ms. Sandridge say.
I don't think that's right, and I know she cited the language in the Florida commentary that says absolute. I'll know that's not in the Model Business Corporate Act. You won't find that. It's not in the statutes. I noticed that they don't discuss the Giulietti case from Connecticut, which talks about the power to revoke is actually the court's power to revoke. And if you look at the Utah case, if you look at the trial cases that were cited below, you'll see that those all include subjects. I don't want to go over my time to finish, but
Council went
Thank
over a
you,
little
Your Honor.
bit, so we'll give you a little leeway here.
thank you. The examples in
We're
the
equitable, okay? We'll give you some time.
Thank you, Your Honor. The examples in the Utah case include all those statutes they cited included a subject in that statute. The same thing with the trial court counsel for Deltron. They cited a bunch of Florida statutes. They all included subjects with the word revoke. We don't have a subject here. The word revoke can apply to court. It can apply to the electing shareholder. And I think that there's two different actions for subsection 1 and subsection 2.
All right. Well, thank you both,
Thank you.
Counsel. Much appreciated.
I'm good to keep going if you want to go. I said I'm good to keep going if you want to go. Yeah.
All right, next case on our calendar today is 24-1266, Riverfront Associates, Riverfront Holding Company versus Jack Weisenbaker Construction and Jack Weisenbaker. 20 minutes per side. would you like to reserve some time?
Yes, Your Honor. Sean Dixon on behalf of the appellant, Riverfront Associates, I'd like to reserve 5 minutes for rebuttal.
Okay.
And as you mentioned earlier, there's a process.
That's true. Thank you for reminding me about that. So would you like to reserve some of your 20 minutes for your?
Yes, 5 minutes, please.
Okay, great. All right, we may proceed.
Thank you. May it please the court. Sham Dixit on behalf of the appellant, Riverfront Associates. Your Honor, we're here on a very straightforward and simple issue, and that is the trial court erred in denying directed verdict on count 6, disgorgement, restitution, and refund. On that narrow issue, it has a large impact on the balance of the case and on the remaining counts and damages awarded, because once the jury found that the culverts were part of the stormwater system, then this meant that Jack Weisenbaker needed a Florida construction license.
This claim, this disgorgement restitution claim, it's equitable in nature, correct?
It is not, I would argue that it's not.
Okay, so, but it was, other than the stormwater system finding, it was agreed that the trial court would hear that portion of it. That was not a jury determination. Is that correct?
That is correct.
Okay.
That's
okay.
right, because it's an interpretation of law.
All right, and so you reference Florida Statute 489.128 for the authority that your client's entitled to be reimbursed for the $2 million because a JWCI was not a licensed contractor. You'd agree that if a license was not required for the work, then that statute would not apply, correct?
If a license was not required, that's correct.
The statute says for the purpose of this section, if a state license is not required for the scope of the work to be performed, then the individual performing that work is not considered unlicensed. So we wouldn't.
That's right.
Right, okay.
It's very binary.
What's that?
It's binary.
Yeah, so but the trial court never really reached the issue of whether or not there was a license or not because they thought the statute only kind of worked one way. They didn't think it worked towards someone defending themselves, correct? So the trial court, as I read the record, I think the record's over like 40,000 pages.
Right, exactly.
But I think the trial court never actually reached the merits of whether a license was required or not based on their reading of the statute. Is that correct?
No, well, it was stipulated that Jack Weisenbaker didn't have a license.
I understand, but for the project, I don't think did the trial court ever make a finding that a license was required for this work or not? I know what the jury found, but the trial court, because my understanding was the trial court, in their interpretation of the statute, did not go any further in finding whether a license was actually required or not.
I believe the denial of the directed verdict is the finding that a license was not required. That's where, correct, in her order on directed verdict, she didn't make any factual findings, but the only reason you would deny a directed verdict is because a license was not required.
So I thought her rendering, again, I thought her rendering in one of her orders was that her reading of the statute was that this only works for someone when they're trying to enforce the contract. I mean, it's like bringing a claim rather than the defending themselves. And I thought she said she was going to make findings later, but never did. Is that correct?
It is, and I think you're referring to the orders on the motions for summary judgment.
I am.
Okay, exactly. Because it was in the orders on motion for summary judgment, she did say, I need additional facts to determine whether a license is required.
So if I would say if we were to agree that the statute worked both ways, for defending and for bringing an action, then, and we thought the disgorgement claim, we thought your claim was properly pled,
Okay.
Then we would need to remand that, correct, for the trial court to actually make a determination whether a license was required in this case, correct?
I disagree with that.
Okay, and why is that?
Because the judge had a special question or interrogatory to the jury to determine whether it was a stormwater system. Once that fact was found, Chapter 49, 105 N3 says a licensed underground utility and excavation contractor shall hold a license. The Jacksonville Code 744.110 states that a construction in a stormwater system requires.
But she would still have to make that finding. I guess that's my question to you. She never actually, I don't want to say she passed on the issue, but it appeared to me her reasoning wasn't based on whether a license was required or not. It was based on her statutory interpretation. So she would at least have to go back and make that finding, correct?
Again, the only reason I disagree with you is because it's implicit in the denial of the directed verdict that no license was required. Otherwise, how do you deny directed verdict after the jury found it was a stormwater system? The fact that she was looking for post-summary judgment order, to your previous comment, it was the post-summary judgment order she said, I need a definitive fact as determined by the jury as to whether a license is required.
Okay, so let me assume your argument is correct, and I'm not saying, just assuming you're correct. There was testimony at trial that about 15% of this work was related to the stormwater drain system.
That's right.
Is that correct? Okay.
Yes.
So 85% of the contract would theoretically not have required a license. So can the trial court sever that? Let's say you're correct on the stormwater system. And I know Judge Scales, there was a case on the third DCA he concurred in, and he discussed this issue, saying that it had never really been addressed, this severance issue. So is that correct? I mean, would you then have to go in and sever out the part that required the license and the part that did not require the license?
No.
Okay, and why is that?
Okay, two reasons. First is you're defeating the purpose of the legislature's intent under Chapter 49. First, for example, 49.127.2a makes unlicensed contracting a crime, right? So it's penal in nature. There are no equitable defenses to it. There's no ignorance of the law. A Florida contractor's license is needed. Next, under 489.128, prevents unlicensed contractors from enforcing contracts. This court last summer in Cam Bradford Holmes v. Arendt found that a contracts entered into by an unlicensed contractor are unenforceable in law or equity by the unlicensed contractor. Next, 49.127 subsection 2 prevents an unlicensed contractor from placing a lien for any, quote, any labor, services, materials under the contract. Then Earth Traders, Florida Supreme Court, says an unlicensed contractor cannot even enter. It's a violation of the statute to enter into the contract, making it void ab initio. So my first argument is to sever unlicensed from licensed work shifts the burden of the penal nature of the statute to the trial court, which is inappropriate. That is not what the legislator wanted. The legislator wanted it to be binary, just like the unlicensed practice of law or the unlicensed practice of medicine. That's why I cited Vista Designs versus Silverman. There, the court imposed disgorgement without a statutory provision because regulatory measures made it a criminal offense to practice a law without a license. Our legislature is holding contractors to the same burden, level, and onus as other licensed professionals. And they're trying to reduce the amount of excuses, if you will, that would burden our legal system because now we're having trials on the severability of contracts. What our legislature determined is that the onus is on the contractor. Jack Weisenbaker could have entered into 2 separate contracts. He could have, it puts the burden on the contractor to say, hey, listen, I'm not licensed to work in a city of right-of-way. I'm not licensed to install 1,000 linear feet of stormwater culverts, but I can move dirt. Moving dirt doesn't require a license. I'll enter into one contract, and you're going to have to hire a Florida licensed contractor to do the other work that requires a contractor's license. To argue severability shifts the burden to the trial court in violation of the legislature's intent to not have to do that. Once there's a violation of law, of violating the Chapter 49, it's binary. And Earth Trades even says the effects of that statute are draconian. It's meant to be penal. So by arguing or allowing severability, you're defeating the purpose of the legislature, period, under the case law and under the plain reading of the statute. And I would even say, but under 49-128-2, it's explicit that the contractor is rendered unenforceable and an unlicensed contractor cannot benefit for the quote, any labor, services, or material provided under the contract. So even a plain reading of the statute as enforced by the court makes it binary. There is no way for an unlicensed contractor to benefit under a contract for any labor or services performed, period. If any portion of that, and I cite several trial courts that have interpreted that statute in our briefs, and so there is no Earth Trades, and in fact, Cam Bradford and Vista, there is no appellate court decision like Vista Designs, where they take it to say that the remedies are X once there's found to be a Chapter 49 violation. I think that's what caused...
So disgorgement is a remedy. You would agree with that, correct? And I know you also would title it restitution. Are you really making an unjust enrichment claim? Is that really the claim that you're making here? Because the argument that they make is that your action is for disgorgement, which is not really an action, it's a remedy. So, but you also have restitution mentioned there, which is a legal, which I think the case law says is a legal action. But do you plead the necessary elements to get there? Is that really an unjust enrichment type action, or are you pleading those elements?
An unjust enrichment action is separate than enforcement of Chapter 49, right? So in other words, unjust enrichment exists in a world in which either the contract was unenforceable for some reason other than the violation of a statute. But, for example, an unlicensed attorney...
So how do you view this claim that you're making? That may simplify that for you. Like, how are you, what is exactly that you're arguing here?
If a contractor or an attorney performs work perfectly, not a defect in the house, the punch list is perfect, everything's fine. In fact, this is one of the arguments that we had in the trial court. Is the contractor, or am I the homeowner, unjustly enriched by accepting the home from the contractor who performed this work without a license? The Florida legislature said no. There is no way to justify or excuse a statute that's criminal or penal in nature. No more than I can write a will without a law license that gets probated in court perfectly, and I would still be sanctioned. I would still be a crime, and I would not be able to benefit in any way from those actions. And so unjust enrichment kind of gets back into that world where there's no statute that's penal in nature. And again, my argument is that it's binary. There's no scenario. Once there's a violation of Chapter 49, the contractor cannot benefit in any way. It's not about me, the consumer. It's not about the onus is not on me to show that the contractor's unjustly enriched or I am unjustly enriched. That's not part of what the legislature's determined for. I think the point of the legislature in making Chapter 49 is to hold contractors to that sort of professional level of standard that reduces the stress on the consumers or the person who is in need of the contracted services and the court systems. They don't want trial judges to have to determine whether there's severability, whether there's unjust enrichment, or any other issues. It's penal in nature, draconian, again, citing Earth Trades. So once this violation occurs, disgorgement is the only proper remedy. If you received $2 million or $300,000 for building a home. The only proper remedy for violating Chapter 49 is to disgorge any benefit whatsoever, because that's what the legislature did when it drafted 49.128 subsection 2. And all the appellate decisions prior to this one, frankly, hopefully, take it to that point where they find there are no defenses in law or in equity. The contract's void ab initio. The contractor cannot defend itself. It's just a matter of determining what benefit, if any, the contractor received and or penalize that contractor for violating Florida law. And for those reasons, Your Honor, I'm going into my rebuttal period, but for those reasons, that's why we ask that the appellate court determine as a matter of law that a directed verdict should have been entered on count 6, disgorgement and restitution. Unless you have any further questions, Your Honor, I'll wait for my rebuttal.
Great. Thank you, counsel.
Thank you.
May it please the Court, Diane Tutt on behalf of the appellees cross appellants. I'm going to, of course, address the disgorgement claim first, and hopefully have some time to get into the cross appeal. I want to start with the standard of review. This is clearly an equitable claim. The parties agreed it was an equitable claim, and that is why it was decided that the judge would decide it. I don't have a record cite for that, but it is clearly something that was agreed to below. There was never a time in which counsel argued that we could not make our equitable arguments in opposition to the disgorgement claim. If you look at the post-trial hearing, that would have been on February 28th, 2024. It's volume 18 of the transcript. You will see that I made all the arguments that I've made in my brief and that hopefully I'll have time to make today as to what are the equitable considerations that the judge should use in deciding this equitable claim. Counsel addressed each claim or each argument that I made, but never said, no, this is a legal argument. You can't even argue any of these equitable considerations. Now, I don't want to mislead the court.
The statute, though, covers, the statute itself at issue says, does not allow the contractor to, it appears to not allow them to make arguments in equity, correct? I mean, it says by an unlicensed contractor should be enforceable in law or in equity by the unlicensed contractor.
It does say equity, Your Honor, but what it's talking about, and this is really my main argument as to why counsel's argument is not well-founded, is that that statute only says that the unlicensed contractor cannot enforce the contract. It doesn't say anything about this binary argument that's being made today. And as I cited a case law in my brief, the legislature knows how to say something if it intended to say something. Counsel keeps saying, well, the legislature clearly in this statute said that the contractor cannot benefit. It doesn't say that. It says the an unlicensed contractor cannot enforce the contract, meaning they cannot sue to enforce the contract. Interestingly, in this case, there were breach of contract claims by both sides. The Riverfront won on its breach of contract claim.
Haven't courts said that they can't bring defenses also?
There was some summary judgments of certain defenses. We were allowed to raise two defenses.
Does that cut across your argument?
No, because Earth Trades clearly stated that if the contractor is being sued for breach of contract, then he cannot make what was the impera delicto defense, which is what was involved in Earth Trades. They cannot raise that. We had one of our defenses the judge struck, I can't remember which one it was, based upon that same theme, but that was a defense. There's a far different difference between an affirmative defense or a defense to a breach of contract claim versus a disgorgement claim that is nothing in the statute mentions disgorgement. Nothing in the statute mentions that an unlicensed contractor cannot benefit in any way by their contract. And the fact is that disgorgement is an equitable action. And I would like to just spend a couple minutes on the standard of review. The standard of review is clearly breach abuse of discretion, clearly. That's been argued to the judge. It was agreed that this was an equitable action. There's no dispute in the case law that equitable actions, in inequitable actions, the courts are required to look at all the facts and circumstances surrounding the claim. And that is what we presented to the judge in this case. We presented this idea that you brought up, Judge Boatwright, about the fact that it's an over $2 million contract, but the culverts, which were the only things that were alleged to have required a license, was about 15% of
Did she ever make a decision, though, whether a license was required or not?
No, she did not.
She based it on your statutory, how you view the statute.
I have to admit, I don't know. It was a simple denial. There was no analysis. At the hearing, she did not make any oral rulings. She entered her orders. And on this particular issue, because we addressed various post-trial motions, on this she just said denied. And I know there was a suggestion that perhaps there should be a remand, but I submit no remand, but not for the reason that counsel indicated, because it's waived. If in fact you believe that the judge should have made some findings, i.e., was there a license required or not, then that's something that the appellant must bring to the trial court's attention before they appeal. Now, I don't have the case in my memory at this moment, but there's a summary judgment case, as we all know. Now, in summary judgment, the judge has to make findings. And there's a case that says that if the judge doesn't make findings and the appellant doesn't bring that to the judge's attention during the rehearing period, then they waive that argument on appeal. At this moment, I think we have to take the abuse of discretion standard at face value and say that, the judge had all of this in front of her. She did not make a decision whether there was a license or not. But let's just say she had in her mind found that there was a license. It's an equitable action, so she's still entitled to consider all of these other aspects. And I know this was a very long trial. It's a very large record. I think everyone, we're all well aware of the length of it. But, several times this issue came up about the statute. Several times the evidence showed that Mr. Weisenbaker reasonably believed that he did not have to get a license, and that is based upon some testimony by Mr. Turing, who is the administrator, architect of the project for Riverfront. And it was also based on a license that said it was for the culverts, but it was said right on there, license not required. And Mr. Weisenbaker was the one, he didn't apply for that permit, but he picked it up. And he saw that. So all of that evidence came up during trial, and the judge heard it, and the judge was entitled to determine that there was some, for purposes of trying to make a full disgorgement of over $2 million, that is one of the equitable considerations, I think.
The permit you're discussing was dealing with the stormwater system, the stormwater drains?
It said culverts. Now, there was some testimony that really was a brush permit, that it wasn't the actual, I have it right here. Somewhere. Nope.
But the permit itself from the
permit
city of
itself-
Jacksonville said they did not need a license,
It
correct?
said license not required, and then when it said what it was for, it said that it was for the culverts. Now, there was some testimony, and I can't find it, I'm sorry, but there was some testimony that actually it was the brush permit for that area. So there was a lot of confusion about this permit, but my point is, and I'm not making a representation to the court, that that the city said there was no license required, because there was this testimony about, even though it said this was for the culverts, it really was a brush permit. But my point is that Jack Weisenbaker picked that up, and he testified that it said license not required. I didn't think I needed a license. And that might not be important in a legal cause of action, but it certainly is important in a restitution, in a equitable cause of action. And let me just, I want to address a couple
Counsel,
things.
if I could ask a factual question. The special interrogatory
Yes.
that had to deal with the culverts and so forth, the jury answered yes to it. Was the installation of the culvert pipes part of a stormwater system? And they said yes. So the culvert pipes were part of a stormwater system. What's the significance of that? I'm still kind of struggling with that,
Well,
because a stormwater system may or may not require licensure, but only thing that's at issue in this appeal is the culvert construction, correct?
There was a disagreement whether the culverts were for the purpose of tidal flow, because this is right on the river. You know, the land had to be reduced in depth so that the tides could come in because of the nature of this project. But there was a disagreement between the parties whether this was a tidal flow for these culverts were for tidal flow or whether they were for storm water. And the jury found stormwater. And why this was significant to the plaintiff is two reasons. Number one, statute 489127 uses that term, stormwater system, saying that you have to have a contractor's license and lists the types of contractors. But that statute is a penal statute. It has criminal penalties in it. There's no private private cause of action under that statute. The statute that's been relied upon is the next one, 489.128, which is the one that we've been talking about, where it says an unlicensed contractor cannot enforce a contract. The reason this stormwater language was also important is because the plaintiff relied upon a local ordinance, I believe it was 744.110, which also said that they listed a couple different categories, but for stormwater, you have to have a license per 489.127. We argue that that local ordinance wasn't applicable because that language that I just read, that I just mentioned to you, only talked about if a right-of-way permit is required, this paragraph is applicable. And that's another thing the judge never found, the jury never found. Was a right-of-way permit applicable? I think they needed that finding in order to have the local ordinance be applicable. But that was the relevance of this language on the verdict form. But the judge, it was conceded, of course, that she would decide count 6. And these were all considerations that were argued to her. The overreaching, asking for the $2.2 million return. The fact that Jack Weisenbaker reasonably thought no license was required, and a few other things that we argued, including that they simply asked for a remedy, not a cause of action. I think we all know what this is, what these claims are. It is
The
a
culvert construction was what percentage of the overall $2 million?
Say it again?
The culvert construction was what percentage of the overall $2 million?
As far as the money, it was about 15%
Okay.
of the total contract.
Any court-allowed severability in these situations?
Not seen that, Your Honor. In my opinion, because this is an equitable action, that was just something for the trial judge to decide. If she had decided that disgorgement was appropriate at all, I believe she could have said, in the interest of equity, I am only going to require disgorgement of the 15%.
Anything in the contract itself that allowed draws for different portions of the contract or different portions of the project?
I know there were draws, but I don't remember whether there were for different portions of the project. The culvert were done fairly early, and the other equitable thing I wanted to mention is they're operational. They're fine. I know counsel doesn't think that the propriety or the perfection of the construction makes a difference, but I think in equity it does. So I think that was another thing for the trial court to consider. Now, I just want to mention this void ab initio argument. That was never pled, that was never made below, argued below. In fact, at one of the hearings, counsel indicated, I think it was co-counsel indicated, no, we're not arguing void ab initio. Because if they were arguing void ab initio, and the court found that, then neither side could could pursue their breach of contract claim. So there's no, this void ab initio, I don't even know where this came from, because the plaintiff sued for breach of contract. The defendant sued for breach of contract. So the contract was not void ab initio. I think that the fact is that this being an equitable action, the trial court had it well within her authority to deny disgorgement for looking at all the facts and circumstances of this case. I don't know what...
I'm sorry to interrupt, but if we send it back for the trial judge to look at this limited aspect of it, and the trial judge says, oh yeah, I find that there was not a license required for the culprit.
If that happens, I still think we can win. I think on an equitable...
That's my question, is wouldn't that just be...
Excuse me?
That's my question. Wouldn't we just be where we are today? If she had said that on the record below initially.
Yeah, I think that if she had just said that, but didn't give any explanation as to why she denied disgorgement, I'd be making the same arguments, counsel would be making the same arguments, because I think that even if there was a license required and it wasn't obtained, there's no statute and no appellate case in this state that says that if you don't have a license, you have to disgorge all of the money that you were paid. The statute simply says you can't enforce your contract. That's all it says. In law or equity, yes, it does. But it's still talking about enforcement. So I don't think it makes a difference. I think that a remand or asking the judge to make a determination about whether a license was required has been waived by the appellant. And I also think it would be unnecessary and it would not make a difference because, for the reasons that I said, because of the equitable considerations here. Am I into my rebuttal already?
You are.
Okay. I'm going to try in just a few minutes to hit the high parts of the cross appeal. On FDUPTA, there's no actual damages. We cited a number of cases in which monetary harm to the plaintiff in the sense of it cost me more to do something, or you stole something from me, or you embezzled something from me, that's not actual damages. Actual damages, the case law basically says, is the difference between the value of what you got and the value of what you paid, and if you got like a valueless product, then you could get the full refund of what you paid. But what happened here was the sale of dirt had been going on for quite a while because they needed to get rid of the dirt for this project. The plaintiff alleged in a separate count, separate facts completely, that Jack Weisenbaker and his company sent some invoices out to these buyers of dirt, these third-party buyers, and kept some of the money. The jury found in favor of the plaintiff, awarding $29,500, I believe it was, against both of these defendants. This is the only personal judgment against Mr. Weisenbaker personally. But that's not actual damages. We move for directed verdict and we move for summary judgment on that. That's a legal issue, and we believe that we should have reversal of the FDUPTA claim on that. Secondarily, on FDUPTA, the case law says there's nothing from this court that we could find, but the 4th, the 3rd, and the 11th Circuit, and the Southern District of Florida, we cited cases that stand for the proposition that although under the current FDUPTA statute, you do not have to be a consumer to file a lawsuit, the harm has to be to consumers. There has to be some harm or detriment to consumers, and there simply wasn't here. The only harm was to Riverfront by not getting this $29,500 of proceeds from the sale of its dirt, because
So they wouldn't be considered consumers in this?
no, and that's what counsel argued, that not only, it doesn't matter whether there's a detriment to consumers, we are consumers, but they weren't. They were a consumer of our work, if you will, but not, the sale of dirt was completely separate. They were not a consumer in connection with the sale of dirt. They were to get the money from that, but they were not a buyer. They were not what you would typically call a consumer of dirt. So for those two reasons, we asked the FDUPTA be reversed. Fraudulent lien, we also have two legal issues on fraudulent lien. First and foremost, no damages were proved at all. The statute 713.31 lists the kind of damages that a plaintiff can get on a fraudulent lien claim. One of those damages is attorney's fees incurred in getting a discharge of the lien. I submit that that suggests that if you already sued to discharge the lien and you paid attorney's fees for that, that's part of your damages when you sue for a fraudulent lien. This cause of action was for fraudulent lien. No, not even a request in the complaint for discharge of the lien. In the exact same paragraph, 713.312B, I think it is, it has a prevailing party attorney's fee. So there's two different attorney's fee entitlements mentioned in this statute. One is damages for seeking discharge of the lien, which never happened here, and the other one is prevailing party. Counsel has combined that and said, oh, well, you know, we have a reservation of jurisdiction for our attorney's fees, so that's our damages. Well, that's simply not true. That's under...
Counsel, you've exceeded your rebuttal time.
Okay.
So I will give you 30 seconds at the end.
Okay.
But assuming, let's wrap it up right now. Okay.
Thank you, Your Honors. From a high level, I want to address a few issues real briefly. First, I want to start with the standard of review argument. Jack Weisenbaker is now arguing on appeal in order to avoid the de novo standard that there were mixed issues, but there weren't. If you recall, she couldn't cite where in the record. That's because the record hurts, and here's my point. The parties in the pretrial stipulation stipulated as to issues of law. In the pretrial stipulation, record volume 7, page 17400 through 17402, the parties stipulated in the pretrial stipulation as follows, quote, whether JWCI violated Chapter 489 Florida statutes, and as a result, plaintiff is entitled to relief, count 6 of the second amended complaint. In other words, we agreed and stipulated that as a matter of law, that is the issue for the judge to decide. So the directed verdict standard is still applicable even though the issue went to the judge under the involuntary dismissal standards. So once we stipulated that the judge could determine this issue as a matter of law, and she denied directed verdict, your review is de novo as a matter of law. And once the jury answered the question, the special interrogatory, that this was a stormwater system, then as a matter of law, you could determine that a license was required because we stipulated that this was an issue of law for the court, i.e. you at this level, to decide. So there's no reason to send it back.
Couldn't you have a stormwater system that has a culvert, but the culvert doesn't require a license?
So I wanted to address that because there is a fundamental misunderstanding in that regard because, and I want to address this point, that 15% of the culverts is somehow minor. Less than 5% of our bodies is made up by our heart. Our heart makes up less than 5% of our body. And if it's not functioning properly, we start shutting down, and it can kill us. That is the culverts. The culverts are the heart of this system. And even if you partition the culverts from the stormwater system, the Jacksonville ordinance, the easement that was entered into between Riverfront Associates and the city of Jacksonville, specifically refers as to the 100% of the area being a stormwater system. Because if stormwater didn't mix, fresh water, didn't mix with the brackish water of St. John's, everything would die. There are creatures that need, animals that need a balance.
Well, it's very important, but the issue is licensure, right?
Now I'll get to that. So once we agree or anchor off the stormwater system special interrogatory, read chapter 49, section 105, subsection N3. Excavation in a stormwater system requires a license. So you can't even discount that 85%. That's why that issue of the stormwater system, the jury, was so important. That's kind of, I believe, what kind of choked up the judge on summary judgment and had her find those issues to be factual. But that should have gone away once that special interrogatory was answered, because it resolved the issue of 15% versus 85. Put a fact that the whole system, the whole mitigation bank dies and no credits would ever be received from the Army Corps. Put that aside. Once the jury answers that question, it made the entire system require a license to work in it because it was excavation in a stormwater system. And then add this, that to install the culverts was excavation in a right-of-way. To install the culverts in the city of right-of-way, which would require a license as well. So again, there's really no way to partition this work whatsoever. And then again, going back to chapter 49 and the penal nature of the statute, to partition would require defenses that aren't available. And so the only correct thing for this court to do was determine as a matter of law that a license was required, that Jack Weisenbaker cannot benefit from its lack of licensure in any way whatsoever, and disgorgement should be awarded. Well, judgment should be entered on count 6, disgorgement on behalf of Riverfront Associates. Thank you, Your Honor, unless you have any additional questions.
Thank you.
Thank you.
All right, 30 seconds to wrap it up.
Very briefly. With regard to this pretrial stipulation that counsel stated, that was waived. If you look at volume 18 of the transcript, which is the post-trial motions, and I'm going to give you the pages, the arguments on the disgorgement were pages 3458 to 3493. I made all these arguments about the equitable considerations, et cetera. There was no objection. There was response. So this pretrial stipulation is a red herring because that was waived. With respect to the argument that because of the jury's finding, that made the entire system require a license, no, that just doesn't fly. It was stipulated below. Only the culverts required a license, and there is a way to sever it by the money. So we're asking your honors to affirm on disgorgement and to reverse on the other 3 issues. The first 2, directed verdict, which is the FDUPTA, and the fraudulent lien. The mistrial, I know, which we didn't have time to get into, that would be for a new trial. Thank you.
Very good. We very much appreciate the advocacy today, and we will be in recess.
Thank you.